Testing, 1, 2, 3, testing. Testing. Those that join late, they'll be able to catch up and view the video or see the screens. So we're welcome to present tonight, Guardianship, a deeper dive, presented by ACMI, Josh Moselle, who is a partner in the law firm of Fraser, I always forget the name of your law firm, Arnold and
Goldberg and Arnold.
Yes, okay. So welcome, Josh. If any of you were here to learn about the inroads to on-ramps to involuntary treatment, Josh presented, and I think during that time he touched upon guardianship and some of the questions surrounding that. So hopefully you'll find this informative. There'll be both legal information in there and also information from families that often find themselves lost in this process. So at any time, if you want to ask a question, put it in the chat. We've also have some pre-submitted questions from people that have sent those in, so we'll ask those as well. And just to see if you're paying attention, we'll have a few polls during the presentation where you'll be able to select what you think the appropriate course of action would be. So with that, welcome Josh, and welcome everyone to our webinar.
Okay, thank you, Lori. And thanks to everybody for coming tonight. This is our third presentation. A month ago, we did that one where I was talking about the civil commitment. 2 weeks ago, Holly Giesel did an awesome presentation on criminal justice system and mental health issues in that system. Tonight, we're going to do guardianship. The point of tonight is to give you guys a practical understanding of what a guardianship is, how to use it, the benefits of it, the downsides of it, how to go about acquiring it if that's something you want to do, and then some alternatives to guardianship, less intrusive measures. So before I jump in, I just want to make sure we know this is an ACME presentation. ACME stands for the Association for the Chronically Mentally Ill. ACME was started in 2017. Time has flown by, but it was founded by a group of parents who were all facing the same issues. Their kids cycling through incarceration, hospitalization, homelessness, and we were working to create measures and interventions to stop that. One thing that made ACME very different from the beginning was that we have a very narrow focus, a laser focus on population and outcome. The population we're focused on is the very most mentally ill within the SMI system. So the term we started using was a small sliver of the SMI population. We thought about 5% of those who were resistant to treatment, to the point where this cycling would be happening. And so one thing that came out of that was consistent problems that we'd run into, consistent dilemmas. And I think this ACME series is kind of trying to address those things. And that's what these webinars are about. One of those common problems is, what do I do with my loved one who is severely mentally ill, is harming themselves to a certain degree, but they're refusing treatment? And that's the starting point for the guardianship presentation. One more point, Lori kind of made it earlier, which is I'd rather have a conversation and answer questions if they come up. I think that's way more informative. It's way more helpful. And so if questions come up, please text them in so that Lori can interrupt me and ask me. One thing that's off limits, though, that I've been getting a lot of grief for at work is my hair. My hair is very long. I need a haircut, and so I know that I don't need questions on it. But if you think this is long, I ran into Jim McDougall today, who I just saw on this call, and his hair is the longest I've ever seen. That guy needs a haircut. I do too, but there's going to be no questions on that. So that's a good segue into mental health law and the underpinnings. And if I could find my mouse, I could skip this.
It's under your hair.
Funny, Lori. Thank you. Okay. All right. So this is a version of mental health law. And I think it's important to take a step back and understand kind of the underpinnings of it. So all mental health law is, for the most part, dealing with civil liberties. And whenever there's a deprivation of civil liberties, there's a balancing of rights. It's the public's interest versus the individual rights that we have. And so there's this balancing, and that's why I put this amazing design of a scale here to represent that. And so when there's an individual right, but the public's interest overcomes that, then the state can step in and take away certain rights. So 2 weeks or a month ago, we talked about civil commitment. Everybody has the right to be left alone, left to be free from treatment until they don't. And as we learned that day, the point at which you don't have the ability to be left alone is when you're mentally ill and you danger yourself, danger others, persistently or acutely disabled or gravely disabled. Holly Giesel talked 2 weeks ago about the criminal justice system. We all have the ability to be free from incarceration and detainment until the scales tip and we do something like commit a crime, or the justice system believes we committed a crime. And at that point, our rights can be taken away. Confidentiality is another place that we have protections, but Chick Arnold always says that everything is confidential until it's not. And there's certain circumstances that would come up and make something that was previously confidential not anymore. Guardianship is the same way. Guardianship is the taking away of somebody's rights. And once a certain threshold is met, then those rights can be taken away. So real briefly, what is a guardianship? Basically, it's a court stepping in and saying that there's a person in the community that needs protection. And to protect that person, we're going to appoint a guardian. And typically, the guardian's going to be given authority to make decisions on the ward's behalf. The ward is the protected person. And they always have to do it in the best interest of the ward, but they're given rights. They step into the shoes of the ward. And so by giving rights to the guardian, you necessarily take rights away from the ward. And so when can that be done? Like I was saying, with civil commitment, rights can be taken away when you danger yourself, danger others, PAD, or are gravely disabled. So when can that happen in a guardianship? There's 3 prongs. This is the threshold for rights being taken away. 1 is that there's incapacity. 2, that the intervention is the least restrictive, the guardianship is the least restrictive alternative. And 3, it's necessary to provide for demonstrated needs. And so
Can you go back, Josh, to not that one, the one before? The slide before this? Okay. Down, a question that seems to always be number 1, I put there at the bottom, that we get all the time about if the guardian's legally responsible for the actions of their ward, financially, criminally, or any other liability. That seems to always be a concern. So could you speak to that?
Yeah, it's probably the most common question that comes up. So in the situation, somebody needs help, right? There's somebody in the community that needs protection. Most of the time, family members or friends step up to be the guardian of that person. But if it were the case that when the guardian went out and did something irresponsible, that the guardian would then be responsible for it, no one would ever be a guardian. And so the state would have to step up and be the guardian for probably tens of thousands of people. because that's the case, there's specific immunity for this. And so if you're the guardian, but the ward goes out and does something stupid, hurt somebody driving a car, you're not responsible solely because you're a guardian. Same thing when it comes to financial liabilities. If the ward goes out and spends a bunch of money, the guardian is not responsible for that debt. Now, I never want people to take it as a shield, like you can let your kids just go out and do whatever they want. If you are negligent, separate from the guardianship, if your kid is drunk and you give him keys to the car and then he drives off, it's not like the guardianship protects you, but it's also not the guardianship that would get you in trouble. It's that you were separate from the guardianship, irresponsible and neglectful. Does that answer the question, Mari?
Yes, I think so. I think that, so what you're saying is typically they're not responsible if they're just acting as a normal person. If they do something that is really negligent, then that crosses a different line, right? A different line in the sand, and maybe they would be, but typically, no, they're not liable for.
No, not quite. So if there's a guardian in place, simply because they are the guardian does not mean that liability flows to them. Like if their kid just went out and did something stupid, liability doesn't flow. But separate from that, let's say that they just acted stupid. They were still the guardian, but they did something incredibly stupid, like give their kid keys to a car when they knew that their kid was drunk. They're going to be held liable probably, regardless of whether there was a guardianship in place. Does that make sense?
Yes, that does. Thank you.
Okay. So like I was saying, these are the three prongs. Incapacity is the first. And this also comes from Chick Arnold, like much of what I say. But incapacity is a moving target, meaning that you could be, the same person could be, have capacity for one task, but then be incapacitated for another. Chick uses the example of, I can make decisions about my healthcare, but when it comes to fixing my car, I'm completely incapacitated. So you can see how there's an ebb and a flow. That's particularly interesting in mental health cases where that's what happens with a lot of mental health conditions is there's an up and a down. Sometimes people are doing really well, they have capacity. Sometimes they're doing terribly and they don't. And depending on the condition, that can fluctuate over and over and over again. It's what makes mental health cases in court particularly difficult. Oppose that to something like dementia that's degenerative and is not going to get better. Once you cross the line of incapacity, you're not coming back. If you have Down syndrome, if you're incapacitated, you're not going to get any better. So there's this ebb and the flow in incapacity in general, but then in mental health cases, it's particularly so. So I laid out capacities to do certain things because I think it's helpful in understanding what we're getting at here. But testamentary capacity that's capacity to create an estate plan. You got to know the nature and extent of your bounty. You got to know how much property you have, and you got to be able to tie those things together in an estate plan. Capacity to give a gift is a higher burden. You have to do all those things plus know the nature and effect of a gift. A contract could be very simple. You're selling a bike, or it could be very complicated. You're selling a business. You might have capacity for one, but not the other. The standard for guardianship is that the person has a deficiency, is impaired by some condition, and then they can't make reasonable decisions about their person or communicate reasonable decisions about their person. Okay. Least restrictive, the second prong, basically means that if there's another route to get to what we're trying to accomplish, that route needs to be taken prior to a guardianship. A guardianship is a very intrusive measure. Go to court, take away somebody's rights. It's a public proceeding. And so the statutes and the court do not want to do that unless it's absolutely necessary. So it's got to be what's called the least restrictive alternative. Then the third prong is demonstrated need. And that means that there's got to be things to be done. There's got to be actions to be taken. It can't be a guardianship in a vacuum, a guardianship that sits there and does nothing. And
Josh,
so,
one thing. I mean, I think it's kind of nice to state. I don't think any parent says, I want to have my kids and make all their choices forever. No one says, I want to be a guardian. I mean, that's like, no, it's the best option sometimes in horrible situations, but no one goes in saying, that's my goal in life.
Yeah. And that when I'm having people testify in court, that's one thing I ask is, are you doing this because you think it's fun? And of course the answer is no. They're doing it because they love their loved one. So where were we? Demonstrated need. Got through that. So I have a few examples that I thought would help in hashing this out. And people, when I presented on guardianship before, they're like, well, how do you know if somebody's incapacitated? I'm hoping that these things help. I'm going to read these, so I apologize, but I can get through them quick. There's a 90-year-old woman who has severe dementia. She was hospitalized after she broke her hip resulting from a bad fall. After arrival, the hospital determined she had lost a great deal of weight because she's unable to prepare meals for herself. She also had several open festering wounds she was not addressing. Because she was falling every day, cannot provide food for herself, and cannot take care of her medical needs, she now requires an assisted living level of care. However, she refuses to go to assisted living and demands to return home. Without help, home is an unquestionably dangerous environment. The hospital files a petition for guardianship. Will it be granted? So if you look at the three prongs, as far as incapacity goes, is she able to make reasonable decisions about her person, about her health care? She can't cook meals. She can't take care of her medical conditions, and she's placing herself in a dangerous environment every day. The answer to that is she's obviously incapacitated. Is it the least restrictive alternative? Without any other facts, I would say yes. What else are you going to do? She needs to go to a safe place. We need to have the authority to do that. And so guardianship would be the proper route. Demonstrated need, here that's consenting to the treatment and the treatment that'll be provided at the placement. And so in this scenario, she would meet the standard for guardianship. But what if we change it and add that her daughter has a power of attorney? She's still incapacitated. There's no doubt about that. But is it the least restrictive? Is it the least restrictive pathway to getting to our goal of getting her to an assisted living facility? No, it's not. The power of attorney can do all of those things. And so here, the court should deny this petition. Whether or not it would do that, I don't know. But that's what the law would say. How would things change if her daughter was willing to move in and could take care of her? This really speaks to the demonstrated need part. Here, she's definitely incapacitated, but what needs to be done that can't be done without a guardianship? The daughter's going to create a safe environment at home, and so there's not a demonstrated need, and so arguably it's not the least restrictive alternative. How would things change if the woman was willing to go to the nursing home but still incapacitated? So that one's kind of like a trick question, because it would seem that, well, we don't need it because she's just choosing to go, but she's incapacitated to do so. And so I would say in that situation, she can't consent to the things that need to be consented to get there. And so if there wasn't a power of attorney and if the daughter wasn't involved, then a guardianship would be appropriate. Next example.
We have a question, Josh. If I have a guardian appointed, can I own or buy a gun?
If the ward is asking that, if
Yes, the ward's asking that.
yeah. So the answer is no. Uh, in a 1964 law that kind of defines all that, it says if you've been adjudicated to be mentally defective, which is old, kind of offensive language, then you don't have your right to a gun is taken away, and while you can get it back by going back to court and showing that you have the requisite ability to be safe with it, you are put on a prohibited possessors list when you're deemed incapacitated by the Superior Court. So whether you get a guardian in place for you, or you go through civil commitment, you lose your right to a gun. It's one more reason that, I mean, rights are being taken away. It's one more reason to be do the least restrictive thing necessary to get the protections in place. Okay, 31-year-old woman, long history of schizophrenia, long history of failed treatment, designated SMI. She's not willing to consistently engage in care, does not tell her doctors her true symptoms or situations, is constantly living on the streets because she's told there's nothing available for her. Because she lives on the street, she is constantly assaulted. She has been psychiatrically hospitalized more than 20 times, arrested on several occasions. She's appropriate for residential services, which is a very high level of care treatment within the system, and assertive community treatment, but rejects the services because the residential and ACT teams are quote unquote fronts for the FBI. She refuses to complete a power of attorney. So Laura, you're doing a poll question.
Okay, so I'm going to submit a poll. I'm going to launch it. You can use your mouse or touch screen and click on what's the appropriate action here, and then Josh will respond.
Okay, well, I'm going to start with the second one here, Lori. So is guardianship appropriate for her? If you look at the 3 prongs, she's definitely incapacitated. If she doesn't have any documents in place, and she's not on COT or something that would give her treatment, and there's definitely a demonstrated need because of all the services that she's rejecting, I would say that the guardianship is appropriate in this situation. Now, will a power of attorney work for her? That's a layered question. If she had periods, like I was talking about the ebb and flow, she might have capacity to complete a power of attorney, and you need to be able to understand the nature and effect of that document. And so if she at one point was lucid enough to complete one, then that might work. The problem with those documents, which I'm going to talk about later, or the downside to them, is at what point they're effective, because most of the time a document is going to say this isn't effective until a doctor says that I'm incapacitated. And so if the person's out in the park, psychotic, it's hard to get a doctor to attach a doctor's note. And then the revocation portion of it makes it really difficult too. Most powers of attorney can be revoked at any time. And so in my experience, it's always the time that you need it that the person revokes. It's always the time that they get really delusional and paranoid and they need to be hospitalized, that they believe that you're part of their delusional system, and so they revoke the power of attorney. And so while I think you always start with a document like this because it is least intrusive, with somebody like her who's been so consistently ill for a decade, been resistant to treatment forever, I don't think that that's gonna work.
So Josh, so for that, you can see there's a fairly high percentage that say try for court-ordered treatment. Has court-ordered treatment ever been tried on this theoretical case? Tried and failed?
Yeah. So this is a real case of mine, and it has, but she's someone who would fall into the chronically mentally ill category. And so, you order her to treatment, but she leaves. 24-hour residential, she's out in a few hours, getting into all kinds of trouble, getting arrested constantly. And so, yeah, she's been put on a number of court orders, but they haven't been all that effective. The next example.
We have a couple questions. One,
Okay.
who is able to file a petition? And if I petition someone, does that mean I will be the guardian? Is it one and the same? That's one question.
No, and we're going to get to both of those things later.
Okay. And then the other one was COT. What does it mean? Court ordered treatment.
Yeah. All right. Okay. 31-year-old man, long history of schizophrenia, serious mental illness since 21 years old, paranoid, delusional, bizarre, dropped out of school, can't keep a job, has medical conditions he doesn't follow up on, refuses all mental health treatment, has never received mental health treatment, increasingly aggressive, confrontational. After a particularly aggressive encounter with parents, took the family car, drove 90 miles an hour on a city street, hit a curb, crashed his car, flew into an open field. Fortunately, he didn't hurt anybody. The police petitioned him. He's currently at a psychiatric hospital. Family calls about guardianship. This was a family I talked to yesterday. The reason I listed it, and I think it's interesting, is because it shows the nuance of this analysis. With the woman, the 31-year-old woman who's had 10 years of her illness, I think it's a pretty obvious case for guardianship. Here, though, and what I talked to them about yesterday was, this is different. This is him for the very first time going and getting treatment, and there's a possibility for success there. Whereas the woman in the slide before, she's been at it and treatment heavy for the last 10 years, 20 hospitalizations. The system's thrown everything it has at her. She doesn't get better. The chances of her getting better without something different like a guardianship are really slim. This guy, however, I think there's a lot of hope for him. And so my advice was, let's wait and see. In 30 days, we might realize that was a not a great decision. But I think that in situations like this, we need to be respectful of somebody's autonomy. Again, statutes are really driven towards independence, autonomy, maximizing self-reliance. And so that's what I think is going on here. I think that if a petition is filed on this in the probate court, the judge is going to grant it. But I think, at least for me, it was interesting to think about the differences. Okay. Next one, 35-year-old man addicted to heroin due to his use, lost job, family, and is homeless. He has several untreated medical issues that he's unwilling to follow up for, let's say because of the substance abuse. So you got a poll here.
Let's see. We are going to do slide 13. So for this case, what do we think is appropriate action here?
So what I would say here is, first, does he meet the standard for guardianship? I think he clearly does. And the reason I put this example up there is, while you can't civilly commit somebody for substance abuse, you can get a guardianship for substance abuse. If you look at the standard, there has to be an infirmity, and that can be mental illness, a medical condition, or an addiction. And so it's different than civil commitment, and that's why I put it up there. So I think, add in a few more facts, he meets the standard. But I would agree with the poll, the victorious poll here, that if a power of attorney can be done, that's always the first line. That's what you go after. Whether or not all of those problems that I talked about are gonna come into play, I don't know, but that should probably be the first step if he has capacity to do it, which that's up for debate. Okay. So this is yours. 57-year-old man recently divorced who has a 22-year-old daughter, no history of incapacity. He has sudden massive stroke in the frontal lobe of his brain. He is basically unconscious and aware of his situation. He has no living will. Hospital needs direction as he is on life support. His ex-wife feels it's not appropriate for her son to step in. Her daughter feels overwhelmed and refuses to step up. What do you do? So there needs to be a decision maker in place. When somebody's at a hospital, there's surrogacy statutes that go through a priority list. Wife is going to be pretty high on the list, but this is an ex-wife. Daughter would be high on the list. She doesn't want to be involved. So that's one possibility. But I think in the end, a lot of these cases end up in probate court with a guardianship. So I would say a guardianship is appropriate. On visiting his home, there are months of unopened letters, bills, and checks indicating that cognitive decline has been progressing slowly prior to the stroke. After you're in the hospital, he continued to struggle and understand and communicate. He cannot find the right words. He does not know his doctor's names or many medications he's on. He has some paralysis of his dominant hand, for which he interferes with daily tasks. He understands that he cannot attend to his own finances and medical needs. He thinks he can go home and live alone. He thinks he can drive. What should be the first approach?
And this one, let me.
So, if the question is posed, what's the first thing that should be done? I think there should always be an analysis of whether some estate planning can be done. And so the answer to the poll is, if the question is what should be done first or looked at first, it's seek a power of attorney. But then you have to look at the circumstances. This person is, I think, beyond a doubt incapacitated, wouldn't know what he was signing. So I think he's likely beyond the ability or the time frame in which he would have had to complete a power of attorney. So I don't really think it's an answer. Let's say he did, for some reason, have some moments where he had capacity and he completed a power of attorney. I'm just looking for potential problems. That would be a good thing if he could do that and
for this one, Josh, it's interesting because it was a family member of my extended family, and again, I didn't want to be a guardian. I didn't even want to be power of attorney, and they live across the U.S. But someone had to step in. But then at the same time, there's discussions in the hospital of can they even make a decision, right? So it was torturous to go through this because I don't know about you guys, but I don't want to run siblings' lives for them at a distance or ever. So it was,
well,
yeah. And we do have a few questions that we could pop in here.
Yep.
Let's see. We talked about the gun. You can't own a gun. If you can't give informed consent for treatment, if you can't think straight, probably need legal guardian. Okay. At some point, if you'd speak about POA, power of attorney, and guardian would be able to do for each of those examples and what they would not be able to do with these examples. So if you had a guardianship on each of them, what does that buy you versus not? And if the person had an established healthcare power of attorney and then gets a guardian, does the power of attorney stand or does the guardian take over?
Yeah, guardian takes over. The other questions we're going to get to later in the presentation. Real quick, guardianship versus conservatorship. The difference is guardianship handles the person, the healthcare. Conservatorship deals with the money. And I guess probably another big difference is that guardianship requires incapacity, which is a pretty high standard. Conservatorship doesn't. Conservatorship requires that you have some issue, some medical condition, something that disables you to a certain degree, and in combination you have property that's at risk of waste or dissipation. So anyway, real brief, that's the difference. So with that said, now I kind of want to shift to what the process is like, how you go about getting guardianship, if that's what you want to do, and some pieces there.
We have a lot of pre-submitted questions on the whole guardianship and the process, so we'll interrupt as we go.
Okay. So the starting point in the process is getting a medical report. And for a general guardianship, and when I say general, I mean not a guardianship with a mental health overlay, you have to get a doctor, a psychologist, a medical doctor, a psychologist, or an RN to complete the report. And the report has to say that, yeah, I've seen the person and I agree that they are incapacitated to make decisions.
Is it easy to get a psychiatrist or a psychologist to provide that report? Are they always willing to?
So that's an interesting question. If you're connected to care, like for, this presentation has a mental illness slant. Let's say that you're in the SMI system, or you've been to a hospital, or you have some attending doctor or outpatient doctor. Oftentimes you're able to get one of those reports. I would say when somebody's in the outpatient world, in the SMI world, I'll say about 75% of the time when I ask a doctor to complete a report, they're completing a report. When somebody's in the hospital, it's like 25% that they're willing to do it. And so some of the reasons are they're doctors and they don't want to be bothered by it. They are worried about having to testify at court. So it's not just the time that they spend evaluating, filling out the report, but then they might also have to show up to court, which is something they don't want to do. And then the most common response is that they don't want to be pitted against their patient. They're basically participating in a lawsuit against their patient to take away their patient's rights. And so that doesn't help their therapeutic relationship. So that's the most common reason for not doing it. And so the answer's all over the board. It depends on the clinical team that you have. It depends on the relationship between the doctor and the person in the system. If you can't get it from one of those places in the system, from a hospital doctor or from your attending PCP, then you have to hire a doctor, which can be expensive. So I mentioned that you have to have another type of doctor if you want to have mental health authority. So if you want mental health authority, you have to have a psychiatrist or a psychologist complete the report.
So Josh, that's a little confusing. So you're saying you could be a guardian over someone, but if they had any behavioral health or mental health issues and you didn't have this other special guardianship, that you could make all the other decisions in their life for all their other medical care or finances, but not that?
Yeah, Laura, that's exactly right. So a guardianship without mental health authority gives you the ability to make all decisions about the person up until they enter a inpatient psychiatric facility. The statutes describe the relationship between guardian and ward as the same between parent and child. So that's how the court and the legislature looks at the relationship, that the guardian can make all decisions, but that is stopped at an inpatient facility. In order to get in order to admit the person to an inpatient facility and then make decisions while the person's in there, you have to get mental health authority, or it's also called inpatient authority or Title 14 plus authority. And so that's an extra thing that you have to go to court and prove. You also have to have a psychologist or psychiatrist testify that they believe that in the next year the person's going to need inpatient care. And so, yeah, Arizona does certain things a little bit backwards. I think this is one of them, but it is protecting people's rights, and they do have a lawyer always assigned to them. And anytime they go in the hospital, that lawyer has to be notified and is meant to do an investigation. But if your loved one is mentally ill and has been hospitalized, and you think there's a chance that they're going to be put in a psych hospital within the next year, mental health authority is really important. So, Laura, you also raised another point, which is, let's say you go and you get a regular guardianship in place, regular meaning not mental health authority, but then your kid needs to go to the hospital. You can file, but you would have to file something with the court, a petition asking that the mental health authority is added, having the doctor sign off on it, and then there's going to have to be some kind of hearing to determine whether or not the person whether the mental health authority can be added. And so it makes a lot of sense to try to add it on the front end if you know that inpatient might be part of the equation.
No, we have one question that's relevant to the reporting. Can the psychiatric evaluation work for this report from an acute care behavioral health hospital? So the actual medical records and notes from a acute incident, can that work in the petition for guardianship?
Well, I guess it depends on what the question is. If a doctor sees the person at the hospital and for a short period of time, but then does a report, that's fine. If we're just looking at medical records, you're going to have evidentiary issues. If that's all you have, you would need somebody to be able to get the records into evidence. But typically they don't directly connect to the standard. Like, they might say that the person was psychotic, delusional, danger to self, but that doesn't mean that the person was incapacitated. And so it's kind of ships passing in the night there. And so if the question is, can I just get records from my loved one's stay? Typically that's not going to work. I've actually never seen it work. So
then another earlier question, what happens when someone petitions a person, the court agrees that this person needs a guardian, but no one wants to be a guardian?
Good question. And we'd hit on a little bit later, but I'll answer it now. If there's no one to step up to be the guardian, there's a safety net, and it's called the public fiduciary. And so in the statutes, there's a priority list that you march down. And if there's nobody available to be the guardian, then the public fiduciary is required to be appointed. So there's a safety net. Let me add one piece of information about the mental health authority. So if you go and get a regular guardianship, typically it's called a permanent guardianship, which is not the right word to use for it. It's not permanent. It can be terminated. It can be adjusted. It's not permanent at all. But if you want to roll it over year to year, you just file a pretty simple report, and then you get a doctor's note and you attach it and you're done. And it rolls over year to year to year. Mental health authority is not that way. You have to, a good deal of time before the hearing, get a doctor to again say that it's going to be necessary for the next year. And if you don't get that in within the required time frame, the mental health authority expires. And that happens all the time to people. So
and another one was, let's see, Under a mental health POA executed after 2016 by law, the person cannot revoke that mental health power of attorney, at times that they are unable to give informed consent. So
Yeah, I saw Jim post that comment. Sure, that's what the law says, but then the law has to enter reality. The law has to enter the real world, and a doctor or a healthcare institution looking at that document, and the guy seeming kind of lucid says, "I revoke this thing." It doesn't work, and so yeah, that is true that they have to be able to provide informed consent, but I haven't seen that be effective whatsoever. What really needs to be done is it needs to be written into the document that the document needs to be written in a different way. The way I write my powers of attorney typically, and people are choosing to do this because they know they don't want to be able to make decisions when they get sick, is I flip it on its head and I say, rather than a doctor needing to say that the person is incapacitated, so it's triggered, or it can be revoked when the person can provide informed consent. I say that I write into my documents that a doctor has to say, I can provide informed consent, and attach it to this document before it's revoked. I think that's the only way to prevent revocation. So anyway, other questions?
yeah, if you get guardianship, and can they be used in other states? What if you travel? What if you move? What if, I mean,
Yeah. So it's a two-part answer. The legal answer is no. These things emanate from state law, and they're not given full faith and credit once you cross Arizona state lines. The reality, and it's kind of what I was saying in response to Jim's question, is it plays out differently on the ground. So we have people that go all over the country getting treatment, and I would say most of the time the care providers are accepting the Arizona guardianship, and so that's not proper, and or proper is the wrong word. It's not what the law would say, but oftentimes they work. The proper way to do it is there's something called the Uniform Jurisdiction Guardianship something Act, and under that act, you can register guardianships really quickly by just filing a piece of paperwork here in Arizona, really one piece of paperwork in Arizona, and 2 sheets of paper in the other state. And there's 46 states that have bought into this act. And then you have all the power that you would in Arizona, and that's called the registration. If the person is moving out of state, then you would want to transfer, you'd want to end the Arizona guardianship and transfer it over. And you can do that. There's more paperwork involved. The court could get involved if the ward wants to object to it. But there's measures in place to avoid relitigating and spending all the time and money to get a guardianship in place. And so the answer is no, it's not good outside of Arizona. There's a pretty quick remedy, but oftentimes it doesn't matter because the providers are willing to provide care, whether or not it's in state or out of state.
Josh, one thing someone just asked if you could say uninformed jurisdiction. What?
I don't understand the question. Could the person ask it in another way? Why that's happening. So you got your medical report. I included the pleadings that you'd have to file. These are documents that you got to submit to the court. At the Maricopa County Superior Court website, there's a list of forms, and there's instructions too about how to go about the process, the things that you need to do. And one of the questions that came up was, can you do it without a lawyer? And my response is yes, just like you can do your own divorce or you can represent yourself in a criminal proceeding. or file a lawsuit on your own, you can do these things too. I think the judgment call, it comes down to how contested it's going to be. If you're going to have to go to an evidentiary hearing, you're going to have to comply with the rules of civil procedure and the rules of evidence. It's difficult, but lots of guardianships are pretty straightforward, and so I think people can do it on their own, and the Maricopa County website's really great for that. Lori, what time are we supposed to be done?
7. Plenty of
okay.
time, and we have plenty of questions too.
Okay, all right. So once you file, then there's a bunch of people that get involved. This was a question that came up earlier. There's a petitioner, that's the person that files the pleadings and is making the request for relief to the court. That person does not have to be the guardian. So, I could file the petition, but propose that my wife be the guardian for somebody that we know. And that happens quite frequently. So those two people don't have to be the same. So the next person is the nominated guardian conservator. Court-appointed counsel is something that frustrates people all the time, because in this process where rights are being taken away, people have to have due process. One of the things that, one of the cardinal features of due process typically is that you have a lawyer by your side. The frustrating part for families is that when the ward says to his court-appointed counsel, well, I don't want my dad to be guardian because he works for the CIA and he implants devices in my brain, court-appointed counsel has to come to court and convey that objection to the court, which increases the time that takes to get a guardianship. It increases the cost to get a guardianship. And so it's frustrating, but that's the role of the court-appointed counsel, is to represent the interests of the ward. If the person...
Who pays for court-appointed counsel? Do the parents or whoever's filing for guardianship have to pay for their potential ward's legal counsels as well as their own?
It depends on if the ward has funds. So in cases where there's a person is elderly and has dementia, lots of those cases people have money, the ward has money, and so court-appointed counsel get appointed and then they bill off the person's estate. So the proposed ward is paying for that. In mental health cases, it's very rare for somebody that is so mentally ill that they need a guardianship, so they're really sick. It's rare for them to have money, and so in those cases, the county, Maricopa County, pays the attorneys for their time, and so there's no bill that goes to the ward. There's no bill that goes to the petitioner. If the go ahead.
Can you ever lose guardianship? I mean, let's say you're appointed guardianship. Are there ever cases where the courts take it away from you?
Sure. If the court doesn't feel like you're the person that's in you're the person that's in the best interest of the ward, they can be removed. I have horrible cases of the system. Some of the systems getting mad at guardians because they step in and they're demanding treatment, and then the system kind of being retaliatory and asking for them to be removed as guardian. And so the ward can file a petition to have their guardian removed, and then you have to go back to court. And if the court agrees with the petitioner, then yeah, the guardian can be removed. It's not a permanent appointment, and it can change quite quickly. Let me get through these next few players in the system. A guardian ad litem is a lawyer that's appointed, but rather than court-appointed counsel who represents the interest of the ward, the guardian ad litem is a best interest attorney. So if a guardian ad litem gets appointed, their task is to do an investigation, be the eyes and the ears of the court, and report back what's in the best interest of the ward. A court investigator is going to be appointed. they're going to basically do the same thing, but unfortunately their reports don't carry all that much weight. In Maricopa County, you're typically going to have a commissioner hear your case, not a judge. It's a lower level judicial officer. The doctor's going to be involved. And then we talked about the public fiduciary being the guardian of last resort here. As far as timing goes, you file your document. If you're asking for a regular guardianship, which means in this context, not an emergency, then the hearing gets set out at least 42 days, so a month and a half. If you're asking for a temporary emergency guardianship and the court agrees that it is an emergency, then you can have an emergency hearing within about 5 business days typically and get temporary appointment. And so you have this hearing that's set 42 days out and you get appointed on day 5, and the court gives you authority all the way up until that 42-day hearing. And then at that point, the temporary authority expires. And if you are victorious with your petition, then the permanent authority begins at that point. So the timing is typically about 6 or 7 weeks. Sometimes an emergency is awarded by the court and you can get it done quicker. So it's not a super fast process. One thing that trips people up all the time is service of process. Got to get a process server, get the word, all the documents. The evidence that's required is clear and convincing. That's your burden of proof. We've got to prove that the person needs a guardian. They don't have to prove anything. And so it's a pretty high standard of proof, clear and convincing evidence. Now, if you're appointed, kind of mentioned this earlier, you have a duty to limit the guardianship however you can. So like I said, the relationship between guardian and ward is parent to child. You have tons of authority. But if the ward at some point gains back certain abilities, like rather than making medical decisions, they can decide where they want to live. They're able to do that. You have to go back to court and let them know that the person has regained that capacity and it should be added back. If they can drive or vote, those things should be added back in. The statutes really drive us towards minimizing the guardianship or the intrusion of the guardianship as much as we can, and as consistently as we can. And maximizing independence there, that's imbued throughout the statutes from beginning to end when it comes to guardianship. And so you have to make a concerted effort to be limiting whenever you can. So when it comes to the appointment, let's say you get appointed in a mental health context, and probably a lot of people on the call that have guardians in place can speak to this better than me. But what it does is, for lots of reasons, there seems to be a divide between the family's involvement and the system, and the system allowing families to be involved. And I think a lot of that is structural. A lot of that is things like privacy laws. And so a guardianship eliminates those barriers. It allows you to be involved with the doctor's visits, to review the chart, to be recommending treatment, to veto some treatment, to be involved with the team as much as possible. Sometimes those who are not doing very well don't report their symptoms, and so they might need a med adjustment, but they're never going to tell their doctor that. And so having extra eyes when it comes to treatment is really important. Also, there's really vital treatments available in the SMI system that are voluntary, like assertive community treatment. If somebody needs that service, it can be a life-changing service for them, but it's voluntary, even if you're really sick. The guardian, however, can consent to it. Residential is the same way. It can be a life-saving measure, but the person can veto it. The guardian can consent. However, even after the guardian consents, the person can leave, and there's not all that much that can be done. Hospitalization is the same way. Benefits are incredibly important when you're trying to get care from somebody. Having an SMI package and being able to make the calls and appeal it if it's necessary getting Medicaid on board, getting all techs on board if that's necessary, all those benefits, SSI, SSDI, all those things are huge, and a guardian can do when maybe the ward can't. But it doesn't fix everything. Lots of times, I kind of mentioned that sometimes teams go after guardians and try to remove them. Lots of times there's involvement in a negative way. So there's a soured relationship between the guardian and the clinical team, and that creates problems. I mentioned it above, but you might consent to a certain level of treatment, but the person just leaves within minutes. I've had that happen so many times. Also, guardianship doesn't have the teeth of a COT. So let's say that the person is psychotic in their apartment, they need to be hospitalized. You have mental health authority. How do you get them from the apartment that they're in or your house to the hospital so that you can admit them to the hospital? Police typically aren't going to do it. Fire isn't going to do it. Ambulance companies aren't going to do it. And so the statutes don't have what's necessary to kind of effectuate that. And the court's not accustomed to granting that power. Even if it were, police and fire wouldn't be accustomed to playing that out. And so there's just a gap there when it comes to inpatient stays that's difficult to overcome. And then I think another one that people are very concerned about is, if I take rights away from my kid, if I'm become the guardian, is my child going to end up hating me? I think it's rare. People on the phone can speak to it better than I can. But it does happen where it creates big divides in families. And so that's one more set of reasons to look for alternatives if you're going to.
Now, Josh, there's a few more questions. One, for those of us who are not attorneys, can you please explain the difference between a preponderance of evidence, clear and convincing evidence, and, oh, it just scrolled up, and beyond a reasonable doubt?
Yeah, I guess that one of my law school teachers said this, and so that's ratcheting up the burdens of proof. But preponderance of the evidence, he's like, it's 50-50. You feel, the judge is like, my gut is here. I feel better about that. He said clear and convincing evidence is like 75% sure. And beyond a reasonable doubt is like 99% sure, 95% sure. So I guess that's for me, that always kind of connected. But clear and convincing is in the middle. It's a pretty high standard. And so you need to have your ducks in a row if you're going to go to court.
Okay.
Other questions, Larry?
Let's see, another one, voluntary inpatient hospitalization cannot force medication or treatment on the individual. Guardians can consent to the meds and treatment, but it can't be forced upon the person. Would you petition for involuntary evaluation and treatment at that point? So I thought if you are the guardian and your ward is hospitalized and they are not agreeing to treatment, if you're guardians and you have the mental health Title 14, that other guardianship, can you say, no, we are agreeing to this? Or do you have to go get COT in addition?
Yeah, so there's a legal answer, and then there's what plays out in the real world. The legal answer is the guardian has the authority to make the decision to give medication above the ward's objection, but hospitals don't want to do that, and they typically just won't do that, and so unfortunately COT is something that in that situation you might be forced to do. Real strong advocacy in that situation might overcome the hospital's hesitancy to do that, but the power of the guardian, again, is very broad. It's like a child. So if your child was in the hospital, could you consent to them receiving medications against their will? Yes, you could. It's the same thing here.
Okay, and in your opinion, if schizophrenia and related psychotic disorders were reclassified under neurology as medical conditions, not behavioral, would current laws and requirements change to make it easier regarding compassionate and voluntary treatment? Probably only one form, not two, right?
Can you reread the question, Mary?
If schizophrenia and related psychotic disorders were reclassified under neurology as medical conditions, not behavioral conditions, would current laws and requirements change to make it easier regarding compassionate and voluntary treatment?
I feel like I'd have to parse it out a little bit. I don't. If they change to be medical conditions, then they wouldn't fit the statutory definition of mental illness, and so we wouldn't be able to civilly commit somebody with that. As far as creating more compassionate care, I think I know where you're going with that, but it seems like more of a almost like a stigma question. I don't know if that's where the person was going, but I could see that being true, that if the disorders were seen not as the thing that has been stigmatized for hundreds of years in our country, mental illness, but as medical conditions, that people would be treated better in that process.
And then
I don't know if that
another
answers the question.
we'll see, they can ask, at what age is guardianship an option? So they got a call from a family worried about the age.
Yeah, 17 and a half is when you can petition for a guardianship, and that'll take effect when the person's 18. You can get a guardian for a child, but it's a different tool. And so in this context, at 18, when the person becomes an adult, that's when you can get it in place.
And someone would like you to go back to the slide alternatives to guardianship for a sec. Nadia, is there a question on this slide, or you just want to look at it?
No, I just wanted to take a picture. Thank you. Done.
Okay, thanks.
Okay. So let me go through powers of attorney real quick. Power of attorney is a voluntary transfer of agency to somebody that you're choosing. So I have a power of attorney for my wife. She's my agent. If I become incapacitated, she gets to make decisions for me. So it's a voluntary decision, and you transfer authority for when you're not going to be able to make decisions. We've talked about it a bunch here. There's downsides to it, but if it's done right and they're not going to be revoked, and we know that it's in effect, if decisions have to be made, a guardianship doesn't have to be implemented, which saves tons of time, trauma, expense. And so healthcare power of attorney can be crafted to do everything that a guardianship would do, which I wish that's the way they operated in the real world, but they really don't. They have these deficiencies. Like the mental health guardianship overlay in Arizona, we have two types of powers of attorney when it comes to healthcare. We have a healthcare power of attorney that covers all of your healthcare up to the stuff going on in your brain. And then a mental health care power of attorney that covers when you go into a psychiatric facility. Chick Arnold has always been offended by this division. And so in our office, we create a combined healthcare and mental health care power of attorney, which I think is a pretty cool thing. But again, the downsides are, when does it become effective? Is it going to be revoked? And then is a provider going to honor these things? And you know, the more I do this practice, the more I realize that it's a problem. Other advance directives, a living will is basically a directive to your agent about what you want to do with end of life decisions. Lots of times families are wondering what is going to happen to my child when I pass away. And so should I just give the money to them? Should I give it to a family member to care for them? Neither of them are probably the right choice. If you give money straight to somebody that's on needs-based benefits, they're going to lose those benefits. So Medicaid, SSI, those kind of things would go away if the person received money directly. Giving money to family members just gets awkward, and it never really works out. The solution in this situation is probably to put it into what's called a special needs trust, which allows you to put money into a trust, but keep the needs-based benefits, and then the special needs trust supplements those benefits over time. So it kind of kills two birds with one stone. And the question there, other expenses that can not be paid from special needs. Yeah, so special needs trusts are pretty darn restrictive. That's one reason that the government gives this quid pro quo about being able to deposit money into account and not be impoverished like everybody else on Medicaid. And so there's pretty darn strict rules. But I think that if we wanted to dive into the details, that might be another webinar that we could do, because there is a lot of nuance there, and people tend to have lots of questions when you do a consult with them.
Now, Josh, so let's say you're a guardian and then all of a sudden you die suddenly, and you have the special needs trust and you have that taken care of. But what happens in the real world to the ward? Do they just, does it,
Yeah.
the court reappoint someone if it's not in your will? Does someone in the family step up? How does that work?
Yeah, so what you should do if your guardian is put it in your will that this person's going to be appointed as guardian, and so then the court's likely going to appoint that person. If you don't do that, then it's basically a best interest, who out there is in the best interest of the person. The saddest cases are kind of when the person has one family member who is the guardian, that guardian dies, then they have to go to the public fiduciary. If you sped up a special needs trust, then there's things called private fiduciaries, which are companies that charge fee for service, and they can step up and be guardian. And I think they're better than the pub fid at being a guardian or a conservator. So put in your will if your guardian makes the most sense.
And we have another question to clarify about earlier. If someone has a guardianship, but the paperwork hasn't been provided to the provider, does the provider have to take the guardian's word about it? And this person works in behavioral health. And along those lines, when I travel with my guardianship papers and mental health authority papers, can you take a picture on your cell phone? Because I often find, especially if there's a lot of activity going on and new providers or different people or insurance companies, that they want to see a copy, a fresh copy.
Yeah, so to answer the first question, no, you don't have to take their word for it. And I would ask them to provide a copy of the guardianship paperwork. And that should not be hard to get. Laura, to answer your question, maybe if it was a good enough picture, I don't know if I feel real comfortable accepting one. The best way to do it though is just to have an electronic copy on your desktop or in your email that you can forward to email addresses. And pretty much all providers are willing to take copies now and don't need the certified copy that's stamped by the court. And so that's what I do, that every day. Send the electronic orders and letters to the providers. Keeping a set of letters in your purse is probably a good idea too. So
Another question, irrevocable durable power of attorney. Can a person become a co-guardian if there's another guardian assigned?
so there's a guardian assigned, but the ward has created a power of attorney that names somebody else's agent.
Yes.
Is that,
Mm-hmm.
that the situation? So the way the court's going to handle it is if that person files a petition to be added as a co-guardian, then I think the court's going to entertain the petition. I think they're going to want to know why the person didn't step up before. They're going to want to know how the current guardian and the proposed new guardian are going to work together. That's really a best interest type thing that the court's going to have to decide. If the agent has a good relationship with the guardian, then I would just work together on filing a petition and then going and showing that you're a unified front. I don't think the court would have a problem with that.
And another one, a long one, procedural question. Can anything be done to streamline the process of getting at least one free certified copy of amended letters? For example, new letters needed each year because of the requirement to renew the mental health powers. Normally, after the motion to renew the mental health powers is approved each year, they submit one. They also need to submit amended letters because the date for the mental health powers has changed, and therefore the letters needs to be updated. But then the clerk charges for a certified copy of the amended letters each year. They've gotten around it by simply filing another motion to waive the fee, but it's yet another form that requires showing income. She thinks that legal guardians should get at least one free since the court law is forcing this requirement for amended letters.
Is the ward impoverished? If the ward is impoverished, then they shouldn't have to pay all those fees. All the, to start a guardianship, there's $700 in fees. All of that gets waived. All of the letters get paid for. And so the waiver should work. And yeah, it's annoying to have to fill out that form every year, but I think it's probably worth it. And that rule, I agree with you. It is burdensome to have to pay $27 or whatever it is now every year just because they require it. But that's just how it is, and that's not going to change.
We had a request to please do a webinar on special need trusts, and then another comment on just a suggestion, make sure you appoint someone not too old. She sent a letter to niece and her husband on your recommendation, Josh, and they accepted to do this job, which is awesome.
Yeah, that's a good point. If your loved one is 30 and you're 68, you're going to have to find somebody, and you want to find somebody that's young enough to take care of them. So yeah, that's smart.
And then also there was a suggestion when you look at guardianship papers, this was to Daniel, make sure to look at the dates that they're not expired.
On the mental health authority?
Yes, and probably guardianship, which I think you said doesn't expire, it rolls.
Right.
Yep. And another question, does court-ordered treatment trump guardianship mental health powers?
Interesting question. If there's a dispute between the outpatient clinical team assigned pursuant to Title 36 and the guardian, yes, it does. The clinical team, given the authority through Title 36 court, wins that fight. If we're talking about kicking them out of treatment altogether, no. But when there's disputes about treatment decisions, yeah, the COT team wins that.
Now we have questions about carrying the originals. We carry copies with us, and we keep the originals in a safe, but we have lots of copies. which I think, Josh, you said that most people will take. Let's see,
Yep.
another one. Does court-ordered treatment trump Guardian mental health regarding medication changes and treatment choices?
Yes.
Okay. And yes, we will have contact information for Josh and his firm. Let's see. And how would you go about finding a mental health smart lawyer in Pennsylvania?
Yeah, mental health lawyers are hard to find. So email me. I work consistently with some mental health lawyers in Boston, and so they're typically, and Chicago. So they're typically my referral sources. If there's somebody there, they'll know. So if you just email me, then I'll send an email to them.
Okay, and then same question, how do you find a mental health smart lawyer in New York State?
Okay, so the person with probably the most robust mental health practice in the country is in New York, and her name's Carolyn Wolf. So if you Google Carolyn Wolf, New York, she's got a very, very significant mental health practice. I'd say the biggest one in the country.
That's great. Now, on the other side, outpatient provider, if a guardian is unable to provide copies of their guardianship, is there some way within the courts that the provider, outpatient provider, could get a copy? They are public records, correct?
Yep. So they're public records. So to get them, typically you have to go downtown to the records department, but you can get all those documents. But yeah, I don't know why the guardian wouldn't provide them to you.
Maybe they can't. The other question that we hear a lot is, how costly is it? You said that people can do their own paperwork, but if you hire an attorney, and I know each case is different, there's lots of conditions and circumstance, but is it like a small t-shirt, a large t-shirt, an extra large t-shirt? Is it like 1,000, 5,000, 10,000, 50,000, 100,000? Where is that bucket to do this kind of work?
Yeah, it's all over, but typically for a straightforward guardianship, again, there's $700 in fees. So the work that we do here is probably, typically it's $2,500. If there's disputes and if we have to do some litigation, it can become more expensive. Also, if you're doing, I described the emergency hearing and the permanent hearing. So you're doing 2 hearings and you have to prepare for those and travel to those and present at those. Because there's 2 hearings, that adds $1,000. So I would say those guardianships end up being $4,500, which is a lot of money. So it's not cheap.
Yeah. Another question, do you know any good attorneys, mental health attorneys in Tucson?
Yeah, Robert Fleming is one of the, he's an elder law attorney, but he can, I guess it depends on what you're looking for. If you're looking for a guardianship, he's the best person to go. If you're looking for service provisions, if you're looking to get engaged in the system, he's probably not. And you could just call me and I could try to set up some things within the system down there.
Also, could the documents, assuming guardianship documents or power of attorney or directed care, any of those vehicles, could they be put in the patient's current health file so it's easy for the providers to access?
That's what I always ask them to do. And I've never really had pushback on that.
And can a person, again, we talked about a person with SMI buy a gun from a private seller. I think that's a little different than can a person that has guardianship, right, buy a gun? That was a no, right? But if this is a straight question, can a person with serious mental illness buy a gun from a private seller? And same question, can they do it if they have a guardian, but it's a private seller, not a public or a store?
Okay. That kind of sounded like the same question to me. So you might have to say it again. But the answer is no, you're a prohibited possessor. If you're a ward, so there's a guardianship, you have a guardian, then no, you're not able to own a gun. If you want to get your gun rights back, there's a process to doing that, and it's not that difficult as far as the filings go. And so I would definitely do that before I went and bought a gun, because you're on that prohibited possessor list.
Other questions too? Let's see. If a diagnosis is schizophrenia, is it certain one can achieve guardianship?
No, because people with schizophrenia oftentimes do very, very well. And then even if they were incapacitated, if they had a good support system and their doctors were willing to talk to their family, then there might not be a demonstrated need, and then might not be least restrictive. People with schizophrenia oftentimes have long periods of time where they do well enough to do powers of attorney. And so, no, not at all.
And if someone was appointed legal guardian in Maricopa County, and now their ward and the guardian live in Yavapai County, is it worth my while to get a legal guardian oversight moved to Yavapai, or does it work all over Arizona?
It works all over Arizona, but it kind of depends on, like, is there mental health authority, and meaning that a lawyer would still be on the case, and that lawyer would have to travel up there. So it makes sense to try to transfer the jurisdiction, which it isn't very hard.
Does legal guardianship give you the authority to remove a ward from a mental health hospital over the objections of the facility, especially if the ward also wants to leave? Perhaps there are problems with the facility and you want to move the ward to be treated at a different facility. What can you do if they refuse? So your guardian, you think that the place, I assume it's a level 1 lockdown of some form, you want to take them out, the treatment team says, no, you can't, they're not ready, you can't take them. What do you do?
If it's a licensed civil commitment hospital, like Desert Vista, Valleywise, UPC, then no. If it's a private hospital that doesn't have those licensures, then they can't hold you against your will. They'll do it. They think they can do it. And so what are the remedies? I would say fight, call their licensing boards, call their executives, call Access. You can file a writ of habeas corpus. But private hospitals don't have the ability to hold you against your will. They do it all the time, but they don't have the authority to do that.
Okay. Can someone tell a local gun salesman to not sell a gun to X? I mean, if you know that, I assume that they're saying that they don't feel that they're stable or should own a gun, but
The question is, can someone tell a gun dealer
do not sell
not
to
to
this
sell
person?
a gun? Sure. I don't see why somebody couldn't say that. I don't know if the person could deny a sale based on it, but gun dealers have discretion about who they sell guns to. So,
Okay. And what does habeas corpus mean?
habeas corpus is a writ of habeas corpus is a legal device that's typically used in criminal proceedings, but it basically requires the jailer, who's ever detaining somebody, to show up to court and prove that they have the legal authority to hold somebody. And so when applied to those hospitals, there's nothing in the law that allows them to hold you. And so if you file a writ of habeas corpus, a hearing gets set. I've only had the hospital, I probably filed 90 of those. I've only had the hospital show up 2 times. and the other 88 times they release. But that's what the device does. It requires the holder of the person who has detained whoever to show up and prove they have the authority.
And again, same one, court order treatment. This one's a little different. It's not guardianship. If a ward is court order treatment in one county and they move to another county, still under court order treatment, can a new doctor change original meds? And does the court order transfer automatically from Maricopa to Yavapai or Pima?
It doesn't, working backwards there, it doesn't transfer automatically. There's a procedure to do it. That's prescribed in the administrative code. And then can the new doctor prescribe meds that are different than the previous doctor? Yes, they can.
Another one that came in earlier, if you are a guardian, do you have to be notified with all of your ward's care? Say they get to a hospital or they want to change meds, anything that's not emergent. Everyone understands if shit's going down right now and they have to do something, they're going to call the guardian after they handle the situation. But is it typical and is it required that they call and discuss the treatment plan and get medical sign off on treatment?
If consent is required, then I would say yes, the treatment team needs to be, or whoever it is, the treatment provider needs to be contacting the ward so that that consent can be provided. I would not say that a treatment provider has to call the guardian for every decision that they're making. That would just be so burdensome for not only the treatment provider, but the ward, but the guardian as well. And there was another part to your question that I didn't answer, but I forgot it.
It was, again, court order treatment doesn't move. That was the other one. This one was, do I always have to be notified about?
Yeah. I would say if it requires consent of the ward for some reason, anything that requires consent, the ward cannot consent to. So you'd have to be notified. Changes in levels of care within the system, there has to be notification sent out about that. That would have to go to you. So I'd say anything that requires notice or consent. But there's so many decisions made during the day that it would just be unrealistic to make the provider report everything.
Okay, and here's another question. We talked about being notified at hospitals and things. Outpatient providers and clinical teams and ACT teams, let's say that they're going to petition or amend someone because they're seeing behaviors that are alarming to them. Do they have to call and notify the guardian saying we're about to petition your ward, or there's an order out for a pickup if the petition was accepted? Do they have to contact the guardian, or are they afraid that the guardian may interfere?
Well, they might be afraid that the guardian would interfere. I would say that those types of decisions, those bigger issues, hospitalization, that yes, the treatment team needs to be notifying the guardian of those decisions.
Okay. And let's see. For a loved one with schizophrenia who only needs oversight, help with challenging government processes, support in legal matters, applying for disability income and such, but not a full guardianship, then a good option might be what? Power of attorney, other options, maybe the directed care? Yeah,
I think that's a good situation for a power of attorney to be done. They're not always honored by those institutions, but I think that's the right situation for a power of attorney.
And does the guardianship magically fix the HIPAA issues?
Yes.
With the providers and the treatment teams and the the evaluation clinics and police and
Yeah.
everyone else?
Yes, it does. Oh my gosh.
And whether each time a court order treatment is renewed, doesn't the legal guardian need to be notified, or can ASH automatically renew court order treatment? ASH is
If the,
Arizona State Hospital, by the way.
yeah, I'd say again, those are proceedings where notice has to be required to the person where the rights are potentially taken away. And in that situation, the guardian steps into the shoes of the ward who is required notice. So yes.
And Chick said there's also a limited guardianship option when only limited authority is needed. So I assume that that means you would outline in that guardianship, here are the areas I'm going to handle. And
Yeah.
okay.
Yep, that's a good option too.
And does the legal guardian need to sign an ROI then if they already have letters? What can the legal guardian do if the facility refuses and says to release medical records unless they fill out an ROI? Well, they just don't know what they're doing. They need, I
Yeah,
think.
but I had that happen yesterday, and then so they don't have to, but just go ahead and do it. You have the authority. I assume you're saying you have to fill out an ROI for yourself.
Yes,
as guardian.
I think
Yeah.
you're saying that.
Yeah, so just go ahead and do it.
Any final questions? Oh, what's ROI? Release of information.
Okay.
If POI is voluntary and revocable by the loved one, is POI, I think like Josh says, it depends how they're written.
Is POA revocable? What?
Is it voluntary and revocable by the loved one?
By the person who?
Yes, by the who would be a ward in a guardian situation.
Yep. Yeah. They can revoke.
Okay, any other questions? If not, we'll move on to asking you guys what other topics you'd like to hear about. We have a lot of other topics that we think would be of interest. The next one, I think, is timely and something that is always problematic within the behavioral health system and outside the behavioral health system is evictions. And why do they occur? How do they occur? What can you do to prevent them? And why should we care? And we have an expert that works at the Community Legal Services that will be discussing them. And then after that, we'll have one on HIPAA, the most misunderstood vehicle. So we could help arm you with information, what your rights are and what they're not. And they would like maybe a session on SSDI and SSI. And I think also it would be very interesting for those that don't know about adult disabled child and how that's important to know and how it will benefit your ward when you take Social Security and how they get a much larger benefit instead of an entitlement. So that would be good.
That would be good.
They don't seem to.
Actually, Lori, an entitlement other than a benefit. Just
Okay. 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 Josh says they don't know what they're doing, which seems to correlate with your weird feeling. Legal guardian shouldn't need to.
Yeah, it doesn't make any sense because the guardian steps into the shoes of the ward. The ward doesn't need to sign a release for themselves, but it's it's a date and a signature on a page, and so sometimes you just got to deal with those silly little hurdles.
I think what we could do, because a lot of people want to contact your law firm, Josh, is on the slides, maybe before this slide, if you want to put in contact information, best way to contact you, and we'll load that up on the slide deck when we load it onto the site.
Yeah. Okay. Can do that.
Yeah. And here's another one. My temporary guardianship was extended because the hearing for permanent guardianship was delayed because of stay-at-home order. Permanent guardianship was extended until May 29, 2020, but the court investigator said the permanent court hearing probably would be rescheduled from April 2020 to late June or early July. The problem is that I have not received a letter extending temporary guardianship beyond May 29th. What should they do?
Do you have a lawyer? So I guess if I had a lawyer, I'd have that person communicate with court-appointed counsel. And during this time, this COVID time, lots of things are getting extended. Stipulations are pretty easy to get done. If you're doing it by yourself, I'd probably do the same thing. I'd talk to the lawyer for your child and see if you can get an extension. May 29th is pretty close, but if you got a stipulation done within the next couple of days, by the end of the week, then typically the court's going to extend it. I don't know if that answers the question, but that's how I understood it.
And one other question for you, Josh. Josh, mental health law seems like a challenging endeavor. Why did you choose it?
Because I worked in the system. I was frustrated by how there are all these barriers put up, and so I wanted to be able to change those. And then I went to law school, and then I met Chick Arnold. So that kind of sealed the deal.
Okay. And if there was, you had your wish, or a magic wand, what laws in Arizona would you like to see changed?
Well, I think the most important laws to be changed are some federal laws that have to do with what gets paid for, and I think we have to focus our dollars on things that are the most important and are going to give us the biggest bang for our buck. For example, Medicaid doesn't pay for rent. I think having a roof over your head is incredibly important, and without it, you can't get stable. And if we spent money on things like that, we'd save money in hospitalizations and city services with first responders. And so I think federal law is more important than anything else. And really it's about where the dollars are allowed to go, because we spend a lot of money on things that are much less important.
And one last question. SMI probationers that are required to register but do not have the mental capacity to register on their own, I do not understand how they can be charged with FTR law. I would like to see change. So I assume that they're on probation and they have to follow a process, but they have challenges. So that seems like it's an odd requirement.
Yeah, that's a Holly question too.
Okay. Yeah, and a lot of thanks for all of this help. Make special accommodations for persons with SMI and Parkinson's. So we will look through these, and we have a whole list of really interesting topics that we think would be interesting. Some of the ones that come top of mind to us too are medication. I mean, there are special psychiatrists that specialize in medication. It would be nice to understand the thinking behind when they're, sometimes to families, and I can say for us, it seems like they go into a hospital especially and they're just like over medicated, or they're trying this and they're trying that. It would be nice from pharmacist perspective and psychiatrist perspective to see what they're thinking and what are they trying and why. And
Right. Well, if everybody on the call could just send like one topic that they thought would be helpful, I think we'd have enough topics for a couple of years, and then we could go out and get the experts on those subjects. So that would be really helpful if everybody just did that.
Yeah, and I think in addition to that, also, how often would you want to hear something like this? Once a month, once a year, once a week? Too much? No, I mean, obviously not once a week. That's way too much. But is once a month a good pace? once a year too little?
Right. Yeah.
Okay.
So,
Okay. Well, thank
okay.
you, everyone. Thank you, Josh.
Yeah, thank you.
I will be uploading the slides up on our site, and we will upload the slides and the video recording. And we're hearing monthly would be